This is a criminal appeal, Lordship. There has been a delay of few days, Lordship.
Same order. Suspension of fine is there. Able to apply for.
Number 2.
Must.
Same. Same order.
Number 3.
May I please, Your Lordship? My Lord, we are agree with the order of the learned single judge, my Lord, only on 2 points, my Lord. One is, my Lord, the learned single judge has held, my Lord, that the Rule 9 was not complied with. It is an autonomous body, my Lord, and we don't have any service rule, my Lord. And it is not mandatory for us to follow Rule 9, my Lord. If my Lord may kindly see the resolution which is passed by the EC, my Lord. The resolution speaks, my Lord, that the respondent was terminated, my Lord. And, my Lord, that the rule should be complied with forthwith, my Lord. But a termination was already done, my Lord. So, termination, as per the resolution, if my Lord may kindly produce the resolution, that is on page 48 of my memo of appeal, my Lord.
But the Secretary of the Executive Committee, Gaurav Hills Autonomous District, has directed you to settle the amount. There is a communication of 3rd September 2025. This is a letter addressed to you as their standing counsel for.
Yes, my Lord. That letter is there, my Lord.
Yes.
Yes, my Lord. They say they cannot settle the matter because they was not in a position to hold a meeting.
Now the situation must be different.
Well, then some time may be given. I will take a fresh instruction on that, whether they want to press this matter or they will settle the matter, my Lord. I'll take the
So
instruction.
there is already a direction that you settle the matter.
They say
The
that,
direction from the Executive Committee of the Gaurav Hills Autonomous Council
my Lord.
addressed to you.
Yes, my Lord.
Therefore, you are requested kindly
My Lord.
to take necessary action in this regard to enable this office to settle the matter once it functions smoothly.
Yes, my Lord.
So
The
what
matter
is-
cannot be settled by me, my Lord. The matter has to be settled by the Executive Committee. What happened, my Lord? After the order was passed by the learned single judge, we have filed an appeal, my Lord. That was the instruction which was
Now,
given.
maybe, but Executive Committee has you are representing the Gaurav Hills.
Yes, my Lord.
They themselves have accepted the order by the communication of 3rd September 2025.
Yes, my Lord.
Then what is the scope for appeal?
No.
They themselves have said
What
the
I
matter
cannot-
has to be settled with the petitioner, but we are unable to release the salaries because of the pending agitation. As soon as the normalcy comes back, we will settle the matter. You are requested to enable the office to settle the matter once it functions smoothly.
My Lord.
Then
My Lord, what has happened, my Lord? I will just give the background of the matter, my Lord. What has happened, my Lord?
background is immaterial now. Question is this because of this.
I will take a fresh
No, you
instruction.
have to settle. You have taken a decision that you will settle the matter. How can you go against it? Isn't it?
No, I'm not saying.
The letter. Huh?
Must pending.
Yes, it's letter.
I have a copy.
Lordship, they have been taking on the pretext of there is agitation. We have given a sufficient time. They themselves will admitted that they are active on the active consideration. To that effect, the order has
We
been
give
passed.
you 1 week's time. Otherwise, I'll call the secretary to be present in court.
My Lord, what has
comply
happened?
with
If,
the
if
order.
I can just point out, my Lord, about this letter, there are two issues, my Lord. One is the matter could not be decided of the petitioner by the executive committee because the salary could not be paid to the staff, my Lord. Because of that, the office was closed down by the.
Now the agitation matter is over.
Yes, my Lord.
So question is, this letter clearly shows
My Lord.
that they will be paid their salaries. You are unable to pay the pending salaries.
my lord.
So they are entitled to the salaries?
No, my lord. He was before the learned single judge for termination of his service, my lord.
Not with regard to the payment of...
No.
Achha, okay. Sorry.
So regarding this letter also, my lord, I will take instruction, my lord, let it come after a week, my lord. I will
No,
just
but if it has nothing to do with him, then...
No. It has nothing to do with it.
Very
This
well,
is in
yes.
connection with the salary of the staff, my lord.
Very well.
Here,
Because of their agitation, you are unable
yes,
to complete.
they take the call. What has happened, my lord, if I can just point out, my lord, after the learned single bench has passed an order, my lord, we have filed an appeal. But during the pendency of the appeal, the respondent herein, my lord, has filed an application tendering his apology and to reinstate him, my lord. He has paid for reinstate. That letter, my lord, could not be disposed of by the EC because the EC could not hold the meeting, my lord. So on that part, my lord, I would like to take an instruction that whether they will consider that letter or they will press this appeal, my lord.
Lordship, may I submit, Your Lordship? Because I deny whatever my learned friend is saying. On the last occasion, Your Lordship, I have approached the authority CM on the basis of the order passed by this group because they have made in the clear before this court, Your Lordship, that they are on the active consideration. Therefore, there is a view that if they are considering this, we went and filed an application. But that application, they have delayed the matter on the pretext that there was agitation. The agitation has been already corrupt. This has been 1 month back. On the last occasion, Lordship has already passed an order. Therefore, this matter has been unnecessarily delayed. This is regarding our termination. And then, Lordship, I humbly pray that this matter can be disposed of because they themselves are admitting that they are not pressing, they are admitting the order passed by the learned single bench. They are not saying that they are not quarreling with the order passed by the learned single bench. There is a finding of the learned single bench is that there was a termination was illegal. Those things I'm not going to say anything, but that order has make it very clear, Your Lordship. Now only thing is that, Lordship.
Pay down.
It pleases Your Lordship. Lordship, I pray this matter may be come up after 2 weeks, Your Lordship, due to the Senior Conducting Counsel was on bereavement. So we could not prepare the case properly, Your Lordship.
Who is representing Union of India? Are you representing?
Yes, Your Lordship. Lordship, here we are just a formal party, Your Lordship.
Lordship,
You are the main
respondent,
respondents.
Main respondent, it's not
main
present
respondent
here
is
today,
respondent 2
Lordship.
to 6, Your Lordship. He has already called me, Your Lordship. He said he's not well, so
Respondent number 2 to 6, who are they? Have you served them?
yes, Your Lordship.
But last time also they are not represented. They were not represented last time.
He informed me, Your Lordship, that he's not well, Your Lordship, today morning.
Who?
Respondent number 2 to 6.
The council.
Yes, counsel of the respondent.
You are for the appellant.
Yes, Your Lordship.
You are Mr. Lalo.
Yes, Your Lordship.
What is this matter?
Lordship, I'm not. Lordship, in this matter, the appellant here, it's claiming the ex gratia monetary relief in lieu of compassionate appointment.
Who is in difficulty, Mr. Chakraborty?
Yes, Your Lordship.
He will not be available for 2 weeks.
2 weeks, 3 weeks, Your Lordship. If possible.
We respondents are not represented. Mr. E.
From supplementary test, item number 1.
May it please your lordships. Lordships, this is an appeal against an order dated 11/11/2000.
How the writ lies? IBC is the
Absolutely, that was our point. But now it appears, the AG has just spoken to me that the parties are trying to go for out of court settlement with respect to the principal and the interest. So therefore, your lordships, so convenient for your lordships, can lordships defer this matter till 28th so that we can check their bona fides, the bona fides of the state. They want to come with a settlement.
now who has been referred to IBC?
The Meghalaya Power Distribution Corporation Limited.
Is an IBC now.
Lordship, the appointment of the IRP has been stayed.
IRP has been stayed by the writ court.
Yes, by the learned single judge. So that is why we came for a vacation and dismissing of the writ petition. But now the impugned judgment has come. But in any case now,
But what is so impugnation says?
impugned judgment says that the corporate debtor is subject to IPC.
So
But at the same time, I am the operational creditor.
no, this court therefore deems it fit that for a proper and complete adjudication on the question of maintenance which is well set amendment. So the main writ petition is kept pending. But you can't have Mr. Advocate General because the judgment is embassy property is quite clear on this point.
Milord, that embassy is in my favor, Milord. I will place embassy and also, Milord, the other judgment, because in embassy and in the Hindustan construct, the principle which has been laid down by the Honorable Supreme Court is that if the entity is discharging the function or extended limb of the sovereign entity, Milord, it may not come under the ambit of the NCLT proceeding, IBC code, Milord. That is what MBC says, Milord, and that is what.
Let the NCLT decide on your objection first. If you are going there, if the time of appointment of an operation, at the time of appointment of an IPO, you just raise this point that you have no jurisdiction.
I raised this point, Milord. I raised this
NCLT
point.
has decided this point.
Yes.
Yes, Milord. It was rejected by the NCLT, Milord. It was rejected by NCLT, and that is why writ I have filed saying that
But that decision is appealable.
Milord, if it is completely barred under the IBC code, Milord, then it is a case of exercise of writ jurisdiction by your
No,
lordship.
that's a
Milord.
different
I
issue.
have-
The decision
Yes,
of the
Milord.
NCLT is appealable.
Section
Yes,
61.
Milord. There are two aspects
It's
of the matter,
applicable.
Milord. One, yes, Milord, in embassy also the Honorable Supreme Court held that if the NCLT has exercised jurisdiction over entity which
No,
is
we are
not
on that.
covered
We are
under
not on that. We are not on that, Mr.
Yes,
Advocate.
Lord.
We are saying
Yes,
that the order passed by NCLT is an appealable order.
yes, Milord.
If it is an appealable
Yeah,
order, it can
I-
appeal. Why should we interfere in the writ proceeding?
Milord, because the
There is an
NCLT
efficacious alternative remedies available under the statute.
Yes, Milord, but at the same time, Milord, your lordship has power to entertain the writ petition, Milord.
Oh, this is
Because-
exceptional circumstances. This is
And it is a
exceptional
case of
circumstances.
It is a case of exceptional circumstances,
No,
Milord. I will demonstrate.
A body has a right to decide a matter wrongly.
Yes, Milord.
So,
But it is a case of exceptional circumstances, Milord. I have relied on two recent judgments of the Honorable Supreme Court squarely on that issue, Milord. That has also been taken note. As on today, Milord, all these questions are open before the writ court, Milord. In division bench, the appellant has come against the refusal to vacate the interim order under 226(3). We can argue all these points before writ court, Milord. Division bench, the appeal is confined to the dismissal of the petition under 226 sub-clause 3, sub-article 3, Milord. Main writ is pending. We can file reply and we can go ahead and argue.
So refusal to vacate an interim order.
Yes, Milord.
Appeal is arising out of refusal to vacate an interim order.
And dismissing the
Yes, Milord. This appeal is
It was a
arising out of
comprehensive
that.
hearing. That is what. If I may place my case,
No, your appeal is because the learned single judge refused to recall the interim order.
and dismiss the writ. It was a comprehensive.
No, dismiss the writ would not have come at this stage. Dismiss the writ would be the final thing.
No, we are saying that the writ is not maintainable. So we were arguing on the whole comprehensive issue. That the writ
But
is,
if the question of maintainability is raised,
Yes, Milord.
that has to be
And
decided
that
by the
has been
court.
yes, Milord.
the impugned judgment has not decided on the question of maintainability. I say that this, but when the interim order was passed, was it passed upon contested hearing?
No. It was the next party.
Ex parte
It
order.
was
Ex-parte, absolutely
order
ex-parte.
and ex-parte order, my lord, and under 226 sub-article 3, the petition was filed. And the learned single judge, my lord, I will show that the learned single judge has gone into this issue of maintainability, my lord. If your lordship will see,
So that issue is now conclusive. So writ lies.
writ lies,
That-
my lord.
yes.
As on today, that issue,
So that
the
that
learned
that
single
issue
judge-
is a closed chapter.
no, my lord,
That has added finality.
No, my lord, to that extent, the learned single judge has said that entire matter will be required to be gone into. At this stage, the interim order need not be vacated, my lord. The sum and substance of the order of learned single judge is this. But in the meantime, my lord, parties are exploring the out-of-court settlement, my lord. Your lordship may have it because it is if I place the facts in nutshell, my lord, in 4 lines, it is a case of Saubhagya scheme under Government of India and State of Meghalaya, my lord. There was certain controversy arose regarding corruption charges, etc. A committee came to be constituted by state government. The state government issued direction to the MEPDCL not to make the payment. It is not a case of financial distress. Then the last month, my lord, cabinet has sat over it. Cabinet has taken some decision, my lord, with regard to payment of the corporate debtor, my lord. And in that regard, my lord, the principal and interest component, there is some negotiation going on between the parties. So I was praying, my lord, if your lordship will have it after 10 days or 1 week, whatever my friend is requesting, lord, lordship, then I will satisfy your lordship that writ is maintainable and it is a case of exceptional circumstances. Because once IRP is appointed on the power company, my lord, then the entire power company will be run by the IRP, my lord, and in my humble submission, it is a sovereign function. Once it is a sovereign function, my lord, it is not amenable to the IBC code, my lord. And
This
then your lordship
issue has already been decided by a division bench of the Madras High Court. That
that issue I will also, that judgment, my lord, that judgment has not gone into that issue, but we will argue those aspects, my lord. Lordship may have it after 1 week or 10 days, my lord, and we can come back, my lord, with to your lordship with this aspect.
You know, this writ appeal is arising out of an order passed.
Wait, please, your lordships. Lordship, in this review petition, we are seeking for review of only the last paragraph of the judgment passed by this by the division bench. Your lordship will come to page 45.
I have no privacy. I have a note on this.
Pause for the file.
That will come to page 45. This is a direction by this court. No?
No, you are challenging which order?
We're not challenging, my lord, we're seeking for review of the
Of-
direction passed by this court for creating a supernumerary post. My lord will find that at page 45.
Why review on what ground?
My lord,
Page 45?
45. My lord, the last paragraph.
In the paper book?
In the petition.
The petition. Give the petition. Yes.
My lord has got it. My lord has got page 45. The last paragraph. Hence, we direct the council and the state to create one supernumerary post. Any approval from the High Court or the government is deemed to have been obtained. Such supernumerary post should be created by 30th of September 2025. Thereafter, a selection test to fill up these posts should be carried out where the appellant is at liberty to participate and to be concluded within a further period of 3 months. In this way, the grievance of the appellant is also redressed. Well, to my understanding, a supernumerary post is created to accommodate a certain person or individual. It cannot be for an unlimited period. What has been done here is that a supernumerary post, we have been directed to create a supernumerary post.
No, what is the ground for review? What is the error apparent on the face?
The error, my lord, I want
Supernumerary post is always a matter of exception.
Yes, exception. That's exactly the point.
It's always an exception.
Yes.
So the division bench, in their own wisdom, thought that there has to be a supernumerary post. We cannot review it. If you are aggrieved, you prefer a special petition. Review application is not maintainable.
My lord, under 215, my lord, this court is a court of record.
Court of record, there is nothing which is causing any impurity to the record. We can exercise our jurisdiction to remove any impurity. That is what we mean by error apparent on the face of the record.
True, my lord.
So that portion is impure.
Impure in the sense, my lord, the Supreme Court has in a katana of decisions held that the...
Let us try your luck before the Supreme Court. Thank you.
Very well.
We'll pass our order.
Obliged.
Thank you. Thank you.
All right.
Over. Thank you. दिया आपने चैम्बर जी ठीक है
Item number 1 and 2.
यस
May it please your lordship. My lord, this is an appeal by the Northeastern Hill University, my lord, from the decision of learned single judge. Now, my lord, the issue before the learned single judge was, my lord, entitlement of the writ petitioner of 3 financial upgradations.
यस
Now, my lord, it is an admitted position, my lord, writ petitioner who was holding the post of stenographer is a stagnant position, your lordship. There is no avenues for promotion. There is no dispute to that. Now, the contention of the university before the learned single judge is this, my lord, as per the MSCP, my lord, the last scheme which is still holding the field, in entire career of a government servant, he is entitled to 3 financial upgradations. And that we have given all the 3 financial upgradations, my lord. Now, my lord, I have laid out a chart, your lordships, mentioning all the financial upgradation that has been granted to him in course of his service career. And he has already retired, my lord, from service. That table is at page 189 of the paper book.
89
189.
18
189.
189
My lord.
yes
Now, your lordships, he was initially appointed in 76, my lord, as stenographer. And at that point of time, my lord, his scale was 330 to 560, my lord. Under 3rd CPC was holding the field,
yes
my lord.
under third CPC
That was under 3rd CPC when he was appointed. Now, my lord, these 330560, my lord, has been revised to, next, your lordship, revised to 12002040, my lord, under 4th CPC with effect from 1986.
yes
Now, your lordship, my lord, kindly look into the right hand side column. Now, he was granted the first financial upgradation. At that point of time, we have a scheme, my lord,
is
one-time
this?
upward movement.
what is this OTUM
One-time upward movement. That was the scheme, my lord, which NEHU has adopted, my lord, on the recommendation of the UGC, and that contemplated 1 financial upgradations. So that was given to him, my lord, with effect from 6/3/94, your lordships, by placing him in the next higher pay scale 16402900. Now, lordship, my lord, will see, my lord, his pay, my lord, at that relevant point of time under the 4th CPC was 12002040, my lord. Now he has been placed to the next higher pay scale 1640 to 2900. So he has been given, because the scheme contemplates very clearly, upgradation means placing, my lord, without promotion, without changing the designation or the work, placing in the next scale in the hierarchy, next higher scale in the hierarchy. So we have placed him. Now, my lord, so far, my lord, first financial upgradation, my lord, there is no dispute in the world. Then, my lord, next, your lordships, my lord, this pay scale, my lord, that was granted.
so you this is this so you put him in the next higher scale
Next higher scale.
post remains the same
Same, my lord.
it's not a,
Post responsibility remains same,
not a promotion
not a promotion. In that way, it's not a promotion, but these are subject to screening.
subject to
Subject to screening. That his service records are all right, he's performing all right. This is subject to screening, my lord. So that he has cleared, my lord. We looked into it. He deserved it. We granted him. So first was done, my lord. Now your lordship will come next. Now this pay scale which was granted to him, my lord, in 94 under OTUM, under 5th CPC, my lord, which came into effect from 1/1/96, this has been revised to 5,500 to 9,000 under 5th CPC, my lord. And in 6th CPC, my lord, further this pay scale has been revised to pay 2 with grade pay of 4,200. Now, if I can take my lord to the next, the second financial upgradation. Now, my lord, the second financial upgradation was granted to him with effect from 3/6/2006. My lord, when, your lordship, that is very important, my lord, here is the confusion. Now, when his case was considered, when the screening was done, that was done in the year 2006. And 2006, my lord,
when his case was considered for the second financial upgradation, and SCP, my lord, Assured Career Progression Scheme was holding the field. Fifth CPC was still holding the field because, my lord, sixth CPC was notified and implemented by the university only in the year 2010, of course with retrospective effect 1/1/2006. So when this second financial upgradation was granted to him, that was under fifth CPC. Now, my lord, here what happened, your lordship? He was given with effect from 3/6/2006 and placed in the next higher pay scale of 6,500 to 10,500. His pay scale, my lord, was 5,000 to 9,000 after granting the first financial upgradation. Now, my lord, second financial upgradation, he has been placed to the next in the hierarchy, that is 6,500 to 10,500. Now, my lord, this 6,500 to 10,500, your lordship, that has been revised under the 6th CPC to payment 2, that is 9,300 to 31,800 with grade pay of 4,600. And then, my lord,
So he was placed.
second was granted. Now, my lord, in the meantime, in 2008, my lord, latter part of 2008, MSCP came into force. Now, MSCP, my lord, speaks about 3 financial upgradation, of course, after adjusting whatever has been granted. 3 financial upgradation. So, these person, my lord, so far he is concerned, 2 already granted. Now, under MSCP, we are under obligation to grant him 1 more. Now, that was granted to him, my lord, by order dated 15/11/2016, third financial under MSCP, by placing the writ petitioner in the next higher pay scale of payment 2 with grade pay of rupees 4,800. So, my lord,
No, see, he was before this 15/11/2016.
lordship,
He was in the grade pay band
Two.
of 9,300 to 34,800.
lordship,
So suddenly with grade pay of 4,600.
lordship.
So this grade pay has been enhanced to 4,800.
Lordship. That is the next higher pay scale in the grade, in the hierarchy.
So what is the challenge? What is the challenge?
Now, he challenged, my lord, he challenged that when MSCP came into force, my lord, sometime in 2008, there is a paragraph in MSCP which say, after the 6th CPC, if the original pay scale, my lord, and the pay scale granted by way of financial upgradation, if they merge into a single pay scale, then that financial upgradation is to be ignored and a fresh financial upgradation is to be given. So his contention before the single judge that 5,500 to, my lord, 9,000, original pay scale
5,500.
to 9,000, from which he was granted the financial upgradation to 6,500 to 10,500. After 6 CPC, they were merged to payment 2 with grade pay of rupees 4,200. 4,200.
No, so under 5th CPC, the revised pay scale was 5,500 to 9,000.
My lord.
Then it was revised to pay band 2.
Pay
With
band
grade-
2?
Grade pay under 6 CPC.
Under 6 CPC with grade pay of rupees, my lord, 4,400.
4,200 is there.
4,400. I'll take my lord to the relevant paper. There was much. So his contention is this thing, as per the paragraph, relevant paragraph in MSCP, this is to be ignored and I should be given a fresh financial upgradation. So for second financial upgradation is concerned. Now, contention of the university, my lord, though initially there was a margin and even university was taking initiative, my lord, as per the paragraph 5. But subsequently, my lord, Ministry of Finance, Government of India issued a notification. Now, in the notification, they have taken it out of the margin. So for my lord, this 6,500 to 10,500 was concerned. And this has been placed in payment 2 with grade pay of rupees, not 4,400, 4,600.
So your moot point is this, that paragraph 5 of the MSCP scheme will not apply.
Not apply. And so far, the learned single judge also said, my lord, he is not onto it. The learned single judge is not into it. Finding is also, my lord, he has not accepted the contention of the writ petitioner.
Then
Because in view of the this being taken out of merger. But he, on a premise, my lord, which is not correct, my humble submission, his contention is this, that second financial upgradation which was granted, that is 6,500 to 10,500, that is a corresponding revised pay scale under 6 CPC with grade pay of rupees 4,400. There is no grade pay, my lord. Firstly, my lord, 6,500 to 10,500. This is a pay scale provided under 5th CPC. And 2006, when, my lord, he was granted this, 5th CPC was holding the field.
no, this was the under the
5th CPC.
When the 5th CPC was there,
Yes,
the higher pay scale was 6,500 to 10,500.
exactly.
Under the 6th,
Fifth
the CPC.
5th CPC. But learned single judge has no, this is the corresponding revised pay scale under 6th CPC with grade pay. There is no grade pay, my lord, under 5th CPC of 4,400. So that is not a upgradation. So you grant him a upgradation
Grade pay was mentioned in the revised, in this,
under 6th CPC.
under 6th CPC.
Under 6th CPC, grade pay.
Before that, what was, there was no grade pay.
No grade pay, man. No grade pay.
So he said that this corresponds to the pay band of 6 CPC.
This corresponds to the corresponding pay scale under 6 CPC with a grade pay of 4,400. Well, there is no grade pay for this pay scale under 5th CPC.
Yes.
Yes, my lord, if I can take, my lord, the finding of the learned single judge.
You can do
My lord, the findings, relevant findings are at page 177, 25 onwards. Paragraph 25 onwards.
Give me the separate one. Yes.
My lord, I will read it. 177, my lord, paragraph 25 onwards.
Yes.
I'll just read it. This, according to this code, is not correct. Interpretation of paragraph 25, my lord, at page 177. Because there is no dispute regarding first, my lord.
Yes.
That is not a grievance of the writ petitioner also. No? Now, 25, according to this code, it is not correct interpretation of the actual position as ought to be. The mistake of the respondent authorities was the confusion created at the time of second financial upgradation under SEP scheme was given to the petitioner. it must be reminded that the petitioner was due to receive second financial upgradation on 6/3/2006. When in receiving the same, he was placed in the scale of rupees 6,500 to 10,500. But in view of the revised scale under 6 CPC, he is entitled to be placed in the pay scale of 6,500 to 10,500 with grade pay of rupees 4,600 as on 1/1/2006. Therefore, on 3/6/2006, taking into consideration that he was then receiving his salary pay of 6,500 to 10,500 with grade pay of 4,600, his next financial upgradation ought to be in the grade pay of rupees 4,800. So, my lord, here is the confusion. There is no grade pay, and this is not a pay scale under 6 CPC. Because when it was considered and granted to him, my lord, 6 CPC was yet to be notified and implemented by the university. That was done sometime in 2010 with retrospective effect. And my lord, 26 also, my lord, with regard to that paragraph of merger. Even if the provision of para 5 of MSCP is not applicable to the petitioner, his next financial obligation under third MSCP, which is due on such and such, should have been given to him in the next higher grade pay of rupees 5,400, being placed in the grade pay of 4,800 under the third MSCP, which was given to him on 3/6/2006. So, my lord, this confusion has started from there, second financial upgradations. If second financial upgradation, my lord, stand corrected, my lord, other thing automatically follows, your lordships. These are in orders.
But how you have extended this kind of grade pay if you are saying that it's only introduced in the 6 CPC to Sri Dhiraj Chakraborty, to Srimati Virginia Dingdor?
My lord, so for their cases considered, this was also, my lord, they have argued. They have argued before the learned single judge. Now, single judge have, my lord, that finding is there, rejected that contention. My lord, at para 20, my lord, page 175.
Okay, very well.
My lord, if I can read it. Para 20, my lord.
He was granted third MSCP.
With
On
grade pay of
24
rupees 4,800.
No, at the time when he received the first financial upgradation,
My lord.
when he received the first financial upgradation,
That is, my lord, in sometime in 94. My lord, in the chart I have mentioned the date is with effect from 6/3/1994.
6394.
My lord.
6394. That is a autumn.
Yes. Under autumn, and there I'll point out, your lordship, we are supposed to, under obligation, to place him, my lord, next higher pay scale in the hierarchy. But
So,
in fact,
no,
he got
so
a quantum
this is-
jump.
No, so this is under the this was under the
What do you have?
fourth CPC. So fourth CPC.
My lord, fourth CPC, it comes to 1640 to 2900.
Now, this was revised to 5500 under the fifth CPC, correct?
Yes.
Now, sixth CPC become applicable from 1/1/2006.
My lord.
But when he was granted the second financial upgradation,
Lordship.
second financial upgradation was granted on 4th September 2009.
My lord. No, Lordship. This was granted, my lord, with effect from 3/6/2006. My lord, I think, my lord, this is a common judgment. This will come to the second writ appeal. I have filed two writ appeal. This writ petition was decided by this common judgment. That was from 2009.
Just a minute. This revised payment of 5200 to 20,200, revised to 9300 34,800, with grade pay of rupees 4200 under the 6th CPC. For the 5th CPC, there was no
No, my lord, no pay.
No grade pay.
No grade pay. No pay.
Where is paragraph 5 of the MSCP?
My lord, I'm just taking your lordship's.
It is started from page 33, the relevant page 36 to the bottom. The LSD scheme 1995-2009 started from page 33 and 36, page 36 is bottom paragraph. Basic draft of the record.
So you are giving the grade pay of 4200.
But my lord, so far this merger,
Now, if you read this paragraph 5,
yes,
it talks about a merger.
yes,
Merger
that's
of
very clearly talking.
merger of two scale of pay.
Yes,
One is 5,000 to 8,000, and another is 5,500
to 9
to 9,000. So these two.
and 6,500.
So by reason of this two financial upgradations
My lord.
under SCP, their revised scale of pay would be pay band of 5,500 to 9,000. In fact, it's 5,000 to, if you take the extreme one, is 10,500.
Lordship.
So in between, one scale is 5,000 to 8,000. The other scale is 5,500 to 9,000.
My lord.
And another is 6,500 to 10,500.
Lordship.
So three scales of pay.
Yes, these merged after 6 CPC.
So
These
it's a
came, my
merger
lord,
of, merger, no, it's just merger of three scales of pay.
yes.
So if with the merger of three scales of pay, what will be the revised pay scale?
Revised pay scale is, my lord, PABN 2 with grade pay of rupees 4,200. They merge initially, my lord, but
So after
subsequently,
this merger, what would be the scale
then,
of pay? They will,
then after the merger, they say, my lord, very clearly, they say, then that upgradation is to be ignored. Whatever upgradation you have
no,
given.
what would be the scale of pay for them after this three scale of pay merge?
My lord.
What would be the scale of pay now after merger?
After merger is PABN 2, my lord. I have mentioned in my table. PABN 2 with grade pay of rupees 4,200. That is, my lord, I have categorically mentioned at page 189.
That is 9,300 to 34,800
Lordship.
with grade pay of
190,
rupees
my lord.
4,200 under 6 CPC.
Under 6 CPC. Only thing, my lord, it is not 4,600 because this 4,600, my lord, subsequently, my lord, these pay scale of 6,500 to 10,500 taken out of the merger by a notification of Ministry of Finance, which I have annexed, my lord, in the paper book at page 100.
That is the class of the matter. That page, the
100.
Ministry of Finance has settled the grievance. They are reading.
My lord will come to page.
By the Ministry of Finance.
My lord, let me finish.
Page.
Page 100, my lord. Relevant paragraph is page 101. Paragraph 3, my lord. May I read it, my lord?
Six people say three revised, yes. But paragraph 3 is a clear answer.
My lord, that is taken out of merger.
No,
So once,
not taken out of merger. It says, consequent upon the notification, such and such, Department Expenditure has received a large number of complaints proposing upgradation of the posts which were in the pre-revised scale. So they were in the pre-revised scale of 6,500 to 10,500. As on 1/1/2006, they were in that pay scale. By granting their grade pay of 4,600 in the pay band 2.
Lordship.
The matter has been considered, it has now been decided that the posts which were in the pre-revised scale of this on 1/1/2006 and which were granted the normal replacement pay structure of the grade pay of this in the pay band will be granted grade pay of 4600 in the pay band P2 corresponding to the pre-revised scale of 7400-11500 with effect from 1/1/2006. This clarifies it.
Yes,
So this is not taken out.
my lord.
This anomaly was removed in paragraph 3.
No, my lord, what I am submitting, my lord, I don't know whether I am able to place it. Now, my lord, after the 6 CPC, my lord, what happened? 5,500 to 9,000, as well as 6,500 to 10,500, my
No,
lord.
whatever is there, paragraph 3 clarifies the entire thing. Paragraph 3, these anomalies were noticed. So this pay band, which was there, they all modified and says that those who were in the pay grade, let's say this 7,000, 7,450 to 11,000,
There is a higher pay scale.
in the pay band of pay 2 corresponding to the pre-revised scale of pay of 7,400 with effect from 1/1/2006.
My lord. Now, my lord, my humble submission by this notification, my lord, now this 6,500 to 10,500, my lord, this is merged with a higher pay scale of 7,500 to, my lord, 11,000. And the grade pay has been upgraded from 4,200 to 4,600. So he gets the benefit. The initial whole purpose of why, my lord, the merger, if there is a actual merger, merge into identical pay scale, that is to be ignored because no benefit ultimately coming to the employee. Now here the benefit comes, your lordships. Because, my lord, what I want to convey, your lordship, is this.
No, this is very clear. The matter has been considered and not decided. The posts which were in the pre-revised scale of 6,500 to 10,500 as on 1/1/2006 and which were granted the normal replacement pay structure of grade pay of 4200
Madam.
to which they were enjoying
Lordship.
in the pay band of pay 2 will be granted grade pay of 4600 in the pay band of P2 corresponding to the pre-revised scale of 7400-1100. So by this, they will be entitled to 4,600,
Madam.
which had been enjoying or corresponding to the pre-revised scale of pay. So the pre-revised scale of pay which was there, the benefit, the pay band in the pre-revised scale of 7,400, 7,450, that grade pay which was there, they should be entitled to that grade pay of 4,600
My lord.
instead of 4,200.
My lord, if I can take your lordship.
Exactly the matter.
My lord, so far, my lord, if CPC is concerned, my lord, even the pre-revised pay scale of, my lord, 7,450
No, this sentence makes it clear. This
11,500.
sentence makes it clear.
Lordship.
All this particular sense of the matter, this clarifies it. Nothing.
Well,
This
I
has
don't
been
know.
settled by the other High Court, my lord. Other High Court, Kerala High Court, full bench, Central
My
Administrative
lord,
Tribunal.
only thing what I am conveying, your lordships, my lord, after merger 5,500 to 9,000 as well as 6,500 to 10,500, my lord, they merged into payment 2 with same identical grade pay of 4,200.
No, they found it an anomaly. That is why this sentence is very crucial.
Lordship,
The matter has been considered and it has now been decided
lordship.
that the posts that is decided, that the posts which were in the pre-revised scale of 6,500 to 10,500 as on 1/1/2006 and which were granted the normal replacement pay structure such and such, that is 42,000 which they were receiving at that point of time, that is upgraded to 4600 which were being received as a grade pay in the pre-revised scale of pay of 7,450 to 11,500.
My lord, in fact, lordship, so for my lord, pre-revised 7,500, my lord, there was no grade pay. There was no grade pay.
Very well.
I can, my lord, take to the list, my lord, I have annexed the pre-revised pay scales. My lord,
Very
so,
well. Anything else?
no, my lord, my only submission is this, my lord, since it has been taken out, my humble submission is this, since it is been taken out of merger, my lord, and
The
it
Supreme
has
Court
been
appealed.
placed,
What your lordship is saying? The same thing Kerala High Court has done. Central Administrative full bench and Supreme Court appealed. I have brought the judgment.
Yes.
my lord, that's my,
Now, please give it to your friend.
Yes. I brought a copy for him.
Yes, give it to him.
I have, my lord, highlighted. That is what.
You have highlighted this very well for us. So you need not read the other part of it.
Kerala High Court, and it went to Central Administrative full bench. Then Kerala High Court, and then
You highlight fully. I see.
and that letter was quoted, my lord, in the Kerala High Court judgment. That what your lordship referred, that was quoted.
No, SLB is pending.
No, page 24, SLB dismissed.
Page 24.
Yes, my lord. That's Thomas case.
Yeah, where is the judgment in the Thomas case?
Thomas case judgment, this is the first judgment.
Is that?
First judgment. Union of India versus Thomas, Kerala High Court. It is went from Central Administrative Tribunal. Page 1, my lord. And relevant page, that circular your lordship have read out, that circular was quoted in page 9 by the Honorable Kerala High Court. First judgment is of Kerala High Court, and the circular your lordship referred is also quoted in page 9 of the Kerala High Court judgment. And relevant page 11, para 3. And thereafter relevant discussion is made page 12, para 5. Page 12, para 5, my lord.
Here, what is the post? Post of it?
Stenographer.
Stenographer.
Same scale, same scale.
Here it is translators.
Here it is translated. And same issue came up. The operative part is page 22, para 9, my lord.
No, here this judgment proceeds on the basis that on the basis of res judicata. It was already been decided, you can't reopen it.
No, 4,600, as your lordship pointed out, their circular was dealt with and it was declared that they are entitled to
No,
4,600.
No, where that was dealt with.
That the lordship will find para 9, page 22. Page 22, running page 22. Para 9, your lordship.
No, we find no, this is the full bench of the tribunal's judgment.
No, the High Court has noted operative part of the High Court judgment, page para 9.
So it says the full bench has already decided, we do not find any reason.
Yes, and full bench also decided in favor of the petitioner,
No,
4,600.
there is no decision on the circular in this judgment.
My lord. No, yes.
There is no decision on this. It relies upon the previous round of litigation
Yes, my lord.
between the
Yes,
parties.
yes.
But the circular was not discussed.
No.
So this is nothing laid down in this judgment.
And it was, my lord, they went to the Supreme Court also.
But here,
Supreme Court
it
upheld
proceeds
it
on the basis that in the earlier round of litigation,
and
the
declared,
contention of the Union of India was not accepted.
yes, my lord.
But why it was not accepted, that is not discussed.
Para 9 clause 3, my lord, declaration directs the
See, paragraph 6 as an indication.
4,600.
Paragraph 6. So the main issue to be examined is as to whether
Yes.
or not the claim of the applicant for the initial great pay in the post of such and such is substantially covered by the final order
Yes.
in the previous round of litigation.
Yes, my lord.
So it was more of an implementation of the order passed in the previous round of
Yes,
litigation.
my lord. My lord.
But there is no discussion on this point. That's the point.
And para 9, they have reflected that entitlement of 4,600, as your lordship said, after Ministry of Finance circular dated 13/11/2009. Page 22, para 9.
But the conclusion, this is a full bench judgment of the tribunal may be relevant, but not this judgment. This judgment has not discussed anything.
My lord, in para 9, your lordship, page.
It's a direction. Para 9 is a direction.
That is the.
Accordingly, find no ground to interfere with the impugned passed by the full bench of the tribunal. So
Right.
you have to see the full bench of the tribunal's judgment. No. That's the reason.
They are also full bench also held, my lord, 4,600. Full bench also held 4,600.
Where is the discussion on the full bench judgment?
My lord, may I take your lordship, page 12, para 5, my lord. Running page 12. Para 5, page 12, my lord. And next page 13, that has been discussed because of the merger. In page 13, your lordship will find regarding merger of 5,000, 8,000, 5,000, 5,500, 9,000, and 6,500, 10,500. Page 13. Merger was discussed. Page 14, my lords, first para.
Yes. Yes.
In my humble submission, my lord, in view of the Ministry of Finance clarification 13/11/2009, the judgment there is no, my lord. Even rather, the claim of the petitioners were rejected, my lord, on the ground of they claimed 6,600 third MSCP. That has been rejected.
Which one?
No, in the prayer originally made in the before the learned tribunal for granting 6,600 as third MSCP, that has been rejected rightly by the learned single judge
In which matter? In this.
in this matter. Rightly rejected in page 28,
Page 28 of the impugned order.
impugned judgment. Rightly rejected. They are entitled up to 5,400. I'm fairly submitting.
Page 28.
Para 28 of the impugned judgment, page 178.
28.
And the learned single judge given what they deserve.
Different dates. Maybe this 8. Find out this judgment. Maybe net. This should be there. This should be Kerala High Court. Kerala High Court. Also. What is your submission?
That's only thing, Your Lordship. I don't know. Briefly, I put what my learned friend is referring, as my Lordships pointed out. Now, my Lord, perhaps things would be clearer, my Lord, if I have an access to that tribunal judgment. That is
No.
That is
See
not
the judgment of the Kerala High Court Division Bench. If you see the judgment, that is I think the third in the list. It's the third in the list. You see the judgment, serial number 3. Of course, the SLP is pending, that's a different issue. But there exactly what he said is being said by come to paragraph, page 11. The paragraph under quotation, we had found as follows. Of course, it was CCS revised pay rules 2008, but the provision was para-immaterial. What is important is you will find that the scale was 7,500, 12,000 as it happened here. It followed therefore that the existing pay of the section officer as on such and such had to be seen as the pay drawn by him in the scale of such and such, in as much as the applicants were drawing a pay of such and such in the pre-revised scale of rupees such and such, which was much less than the minimum pay in a scale of 7500 to 12,000, their existing pay for the purpose of the rules had to be taken as to be 7500, which was the minimum in the revised pay scale. So if we take that into consideration, pre-revised, then he will fit into that claim of, instead of 4,200, it will be 4,800 or 600.
4,600. 4,600.
So this is the logic. When you make this, by this what you do, you upgrade their grade pay, which at the pre-revised scale, which they were as they were existing in the pay scale of 7,500 such and such.
Okay.
So the grade pay to which they will be entitled will be now by reason of this merger would be 4,800 and not 4,200. That is our reading of that particular rules.
Of that compilation given by Mr. Chandra, page 35. Lordship was referring to that.
35.
Page 35. Internal page 11.
What you need,
Page 35. Yes, page 35 of the paper book.
No.
Of the
Judgment. I just
of the
read that.
compilation submitted by Mr. Chandra.
35. Yes, this man.
This is a part of the Kerala.
Yes, madam. But I just conclude with one submission. My understanding, I may be wrong, Your Lordship. What I have seen in the scheme and all, my lord, the merger and my lord, why merger and why it should be ignored. The reason, my lord, obviously apparent after reading into the scheme. Say, for example, my lord, in this case, my lord, second financial upgradation 5,500, 9,000. From this, he was upgraded to, my lord, 6,500 to 10,500. Fifth CPC was holding the thing. There was no great payment. Now, my lord, initially after the MSCP was issued, my lord, after 6 CPC, 5,500, 9,500, my lord, both merged into payment 1, great pay, 4,200. So obviously the reason, my lord, because of the pay revision, my lord, he did not get any benefit. This would have been, my lord, this would become his corresponding revised.
No, so you see that possibly the reason could be that the pre-revised scale of pay
Lordship.
to which the grade pay is now fixed
Lordship.
was by reason of the fact that that scale of pay has now been revised in the meantime. And it could be by reason of the price index or the inflation that it could be.
Lordship.
So that is why they are fixing it, that is taking that particular grade, rather pay scale
Lordship.
for the purpose of the grade fixation of grade pay upon merger
Lordship.
of the different pay scales. Because by that time when this is issued, that pay scale of 7,500 is no more 7,500. This scale of pay may be 10,500.
Lordship.
But that was held to be the yardstick, or maybe that was maybe the base point for the purpose of rationalizing it. That's our understanding.
I'll leave it to your lordships. I'll leave it to my lords.
Thank you. We'll pass over. So,
Similar, my lord. The second petition is similar.
Same.
Only date, my lord.
Only
second,
date of
second
appointment is
petition,
different.
sometime in
Only.
2009, my
And
lord.
page 99, your lordship, this all the revised scale, page 99 of the writ petition, revised scale, and the 6 pay commission scale was page 99. Very important, my lord. Page 99 of the writ petition. Writ appeal.
of the paper book.
Of the paper book, page 99. It is 5th pay commission and 6th pay commission. That has been comparative table has been given. It is a page from CCS revised pay rules 2000.
We pass for common order.
My lord. My lord.
Number 3.
Obliged.
Obliged, your lordship. Deeply obliged.
This separate matter. So these two, we just send it to my chamber with the judgments announced.
Lord, this matter, my lord, pertains to Garo customary law, my lord, the succession and inheritance of Nokmashit, my lord. My lord, I'm in this matter today, I'm seeking for some accommodation today, my lord, for want of instruction.
Just give me the judgment of the single judge. It's the separate image. Thank you. So you filed writ petition.
My lord.
So writ petition was dismissed
Yes.
on the ground that there are concurrent findings of
The two
the
different.
executive member and the non-chief executive member of the council.
My lord. Well, I'm seeking for some accommodation today, my lord, for want of instruction. Because, my lord, in this matter, my lord, we have a feeling that we had earlier appeared for the respondent, my lord.
Sorry?
We had a feeling, my lord, we had earlier appeared for the respondent in the appeal,
You?
my lord. My lord, our office.
No, Mr. Hazarika appointed for the appellate.
Right, my lord. At
Rather,
that time,
the
in one
petition.
point of time, my lord, we have a feeling that we had appeared for the respondent.
So, Mr. Hazarika is not
No
appearing.
longer, my lord, in the appeal, he is not.
You have been recently engaged.
Yes, my lord.
But you are under the impression that you may have
We have appeared for the respondent, my lord, in one of the
for the
appeals.
respondents in this
very
proceeding.
appeal, my lord. Yes.
In this proceeding.
Yes, my lord.
Mr. P. Nongbree
I am speaking.
and Emil Nonjipur.
This is my junior colleague.
My lord, in fact, there had been 3 rounds of litigation earlier.
So you may have represented the Garo council.
No, my lord. The Garo council. Garo council is represented by me, my They,
No.
for the private respondent, my lord.
No, you are the petitioner. Okay, you represent the private respondent.
Private respondent.
That is respondent number 4.
Right.
Very well. The joint counsel appearing on behalf of the